going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy. Is it Wednesday? It's Wednesday. Hump day. Happy hump day. Hope everyone's well. Hope you guys had a great day. Halfway through the week, we made it. Only 2 days left till the weekend. All right. Who wants to watch some court? I want to watch some court. Got some good ones. Let's see. We got Judge Stevens, Judge Simpson. Then we finish up in Reno. Got 2 Stevens clips, 1 Simpson clip, and then I got a couple from Reno from today. All right. You guys ready? Before I hit that play button, you already know what to do. Hit the like and subscribe to your jump kick backflips. Let's go.
Who's on it?
Yes, sir. I believe Mr. Choate's in for Mr. Floyd.
Yes, Judge.
Okay, cause number 20-34861 is now called the State of Texas versus Daniel Joseph Cranmer. That's you, sir.
Yes, sir.
I've heard a couple things. He said himself that he munches on gummy bears, that he likes something chewy, just when he's sitting on the bench. Now, I've heard other people say that he said popcorn before. I know in the intro he mentions popcorn, but the one time I heard him actually talk about it, it was gummy bears. So, yeah, to the best of my knowledge, he chews on gummy bears. So I'm just going to keep it with that.
And I have a motion filed by John Floyd and Chris Show, attorneys of record for the defendant. And you are Mr. Show.
That is correct, Judge.
And where's Mr. Floyd?
He wouldn't call them THC gummy bears. He would call them what I can never even do it. Tetra, Hydra, whatever it is. I don't know what it is. But he never says THC. He always has to say it out when someone tests positive for it. But that would be funny. That would be funny if someone swabbed his gummy bears just one day. It would be funny. That would not be nice to do to him. Kind of funny though.
Floyd today.
Mr. Floyd was in court in Harris County. He is on his way back to the office, but he had court in Harris County.
All right, there's a motion to withdraw that's filed. Please summarize it for me, sir. Thank you.
Thank you, Judge. Primarily, there was a legal services contract in which a trial fee became due upon the case being set for trial. That happened back in 2021. Numerous reminders were sent to Mr. Cranmer along with phone calls. It ended up being that he would not respond to our emails or our phone calls, which created some conflict. And the couple of times that he did respond, he said that he had the money, he just wasn't going to pay it. And that began to create resentment between the firm and him. And we're at the point now where we've never filed a motion to withdraw for failure to pay fees, but we've finally done it after my 13 years of working with Mr. Floyd, because the relationship is irrevocably damaged because we cannot rely on his word, and it creates problems for us taking anything that he has said at face value, Judge.
All right. Generally, the court is sympathetic toward issues on pay, but this one, in all cases, are circumstance based. This is a case that was indicted, going on, was 3.5 years old, over three and a half, going on 4 years. The date of the event in the indictment is 2010. That's 14 years ago. This is continuous sexual abuse of a child. Of a complainant in a serious case like this has to be thought of as well. Are we saying we want to grant the motion, have the defendant start over in finding an attorney, and someone's going to talk to the complainant and say, I know this is 14 years old. You're going to wait another 4 or 5 years?
We understand the.
No. When were y'all hired? What was the date you were hired, please?
In approximately 2020.
And now, when is the trial? When is the trial date?
April, I may,
In 2 weeks?
2 weeks, yes, sir, April 15th.
So you file it on April 1st, as we are coming up to a case that's almost 4 years old. On the eve of trial on a continuous sexual abuse of a child, this is brought up to the court on something that, according to you, has been a systemic problem for years?
We understand how it looks, Judge. I personally would have.
What it is. It's what it is. It's not what it looks like. It's what it is, isn't it? What's wrong with my analysis on that?
We have never had to file a motion to withdraw for failure to pay fees. The problem is that Mr. Cranmer has finally pushed our final buttons, and we have had to file this because we no longer can rely on being able to communicate with him or to have any sort of good working relationship with him, Judge.
Julie, that's awesome. And welcome. Thank you for becoming a new member. I appreciate it. And yeah, we are all fans of We'll All Talk with Mike here. The big old circle. Got Mike, Biggin, Credence and Mikey. It's Natalie's fault. And I don't know. I hate making lists because I always miss people. KCC. Yeah, we just send each other back and forth to each other's channel. It's awesome. But welcome, Julie. Thank you so much. Yeah, the attorney, this attorney's like, just get me as far away from this guy as possible, man. Wait until you hear how much he owes, though. I would be upset if I was the attorney too.
We regret having to file it, but we had to file it, and we do understand that it is a delay in the case. However, we do not feel that there is any more of a working attorney-client relationship at this point. And our concern is that if, depending on what happens at trial, if this came back at a writ, it becomes a problem for everybody as well because of the antagonism between us and Mr. Cranmer.
I think that's something you're going to have to deal with. I just find this inappropriate at the timing of this for something that has been bubbling under for a while on the eve of one of the most serious types of allegations in the penal code, continuous sexual abuse of a child. To tell me that y'all need to be released because of a problem that's been going on for years with your client, that's not timely, sir.
I understand, Judge. We tried to give him every possibility to communicate with us and to meet his obligations on the contract. And he.
How old was the child victim at the time of this? Younger than 14?
Yes, sir.
Okay, in a case like this as well, in determining whether relief is to be given in a case involving a sexual assault of a child younger than 17 years of age, such as in this, the court can consider the impact on the victim of the continuance or a release at the eve of trial after years of representing a defendant. And the reason that you're giving me is something that is no different from the reason that existed years ago. And on the eve of a major trial like this, the court finds that it's not appropriate. It's not fair for all parties. And it certainly could have been dealt with long ago so that on the eve of trial, we don't start up from a cold start on a major case, because any lawyer rehired in this, it's going to take a while to prepare. Maybe we all know that. And we're talking now about a case that's going on, an event that occurred almost 15 years previously. And we're heading up toward 4 years from the indictment, and several years your firm has been representing the defendant.
Judge, I will say for the record that Mr. Floyd has been in touch with me on a continuous basis concerning this ever since I've been on this case. And I know he's spoken to the previous attorney numerous times just to let the court know they have been working on the case.
What does that mean?
I just that this is just one of those that they've always been honorable with me. And
I'm not saying he's not.
No, and I
It's just-
honestly believe it's just.
Well, you're representing the state. What do you have to say about this? You got
I
a
want to go to
victim.
trial, Judge.
Okay.
We've got a victim that needs to go to
You
trial.
disagree with a continuance. You want to move forward.
Yes, sir. I understand their position, but I've got a complaining witness that's been.
Thank you, Mary. Thank you for the super chat. I appreciate it. Yeah, getting paid always feels nice, doesn't it? Kathy Berry, thank you so much for the 5 gifted memberships, and welcome to the new members. Members only Mondays, every Monday. We have a good time. Come check it out. It's fun. Yeah, this defendant, man, he not only did he do a really vile thing, he's pissing off probably the only person that's, somewhat defending him. And yeah, all right. Now we're gonna get to hear Judge Stevens like, no, trial's in 2 weeks. This thing's been going on for 4 years. This act happened 14 years ago. No, we're not doing it. We're not doing it. Sorry, attorney. I don't care how much money he owes you. But just wait. It gets good.
Waiting for numerous years to get this taken care of, and we're going to take care of it.
All right. The courts have ruled on motions to withdraw in the past, and I'm citing a recent case, Reed versus State, where the attorney similarly requested to withdraw for payment reasons. And it was and the trial court granted the motion to withdraw. Then the Court of Appeals ruled that the trial court abused its discretion in granting the trial attorney's motion to withdraw. And the court's decision on a motion to withdraw is an abuse of discretion review standard. And we could go, it's a never-ending list of what factors can be used. There's no real set litmus test, but the disruption that may result in a trial proceeding as a result of the attorney's withdrawal is an issue. But here it says the attorney's role, if any, in creating the need to withdraw. You've told me for years y'all have been having a payment problem, but that was something y'all decided to address and stay with and deal with. And then on the eve of the trial, again, when's the date set for this trial?
All right, I was trying to wait till he was finished talking. Yeah, I find it very satisfying watching the lawn care videos where they kind of fast forward just mowing and cleaning up someone's lawn. They'll do a whole lawn. It takes them about 8. I don't know. I just said 8 hours. I don't know how long it takes them, but they put it into about a 5-minute video. I'll watch those, and I don't know why, but I find them very satisfying. All right. Let's finish up this one. Yeah, let's go.
Judge in a week and a half.
April, in a week and a half. On a major trial like this, which generally takes a week or so to trial. I can't say that the attorneys didn't help in creating this problem that I have to deal with right now that's in my lap.
Oh, the power washing ones are good too. Yes, I agree with that one.
What,
I don't know.
Mr. Cranmer?
I don't know why those videos are so satisfying, but they are. I mean, I've power washed and I've cleaned yards before, and they're not fun. But when you watch someone do it, I don't know why, but it's satisfying.
Yes, sir.
Well, you know you've had an issue paying your attorney.
I offered the best I can offer at this point, which would be to use a combination of credit cards at the very last minute, just because it's going to really destroy my financial situation. Unless I'm looking at being on the other side as one way or the other.
Well, you can imagine how your financial distress
It's bad.
is not something the court sympathizes with. That's your problem. Like, it's everybody's problem. Finance is everybody's problems. But once again, this thing has been around for almost 4 years, this serious matter. And you've had other things you think are more important to pay for? So, no, I hate to get involved in a financial thing, but what are you able to do to pay these people to help you?
What I've outlined,
Sir?
what I've outlined.
How much are we talking about?
On top of the almost 30,000 I've already paid, they are requesting 20,000 for the
Oh,
trial.
well, that's, I don't want to know the specifics. How much are you able to pay?
At this moment, if I had to pay right this moment, I might have.
In your
1,000
master
bucks.
plan, you have about your credit card
Oh.
situation. How are you going
I should be able to pay it off by that,
by when?
by the week of trial. That's what I'm working with.
Oh, okay. Okay, he says, did you hear that, Mr. Show?
I did, Judge, and I apologize, but this is just another example of how we can't rely on his statements because he's been telling us all along that he can pay it.
Well, he's not going to dun me, which is called dunning. That's a term used when you try to fake people out about the money. You're going to be held accountable, and we're going to see where you are in a couple of weeks. And I expect your obligations to be satisfied based upon what you told me. We're going to have a hearing on this. We're going to have to postpone this case for a couple of weeks. But in 2 weeks, you're going to either be good for your word or you're going to be good for your word in jail. I'll hold you in contempt because I'll rely on what you have to say. And we're not going to start from a cold start and have an attorney have to get ready for months and months on a case this old. They put in the time, and I expect And it's all fairness, you have an obligation. But I'm finding that by dunning them, you are also dunning the court and misleading the court on your obligations, which you will pay for if I find you don't honor them. So you take care of this, because I don't want something to start over again on attorneys. You work with them. They're good lawyers, but don't lie about things. They need to know where they stand as well. But this case it's too old.
Your Honor,
This needs to
I
be
have
moved
not- I
forward.
have not tried to lie. My situation has changed, obviously.
Everybody's got financial problems. Welcome to the planet Earth. We all have financial problems, but each of us have to figure them out. Every one of us have issues.
On the 15th, we're not for trial. It's a hearing to see where we're at. Is that
Yes.
correct? Okay.
That's what I'm going to do.
With Mr. Floyd.
All right. That's pretty much it. That's kind of crazy though. So I don't know if you heard, we were talking about mowing lawns and power washing and washing carpets. Yeah. Welcome to my channel. We come for the chat and there's just court playing in the background. I feel like that's happening more often than not now. I love it. Anyways, Pseudo, this guy, CSC of a child. That's what he did. And the crime happened 14 years ago. And the case wasn't filed till 4 years ago. So this has been going for 4 years. And his attorneys are trying to withdraw because he owes them $20,000. So Judge Stevens just said, if you don't pay them their $20,000 by the next time we see you on April 14th, he's got less than 2 weeks to pay his attorneys $20,000. Or he's going to be held in contempt, which is kind of crazy that the judge can do that. If you don't, I'm not letting your attorneys withdraw because you owe money. This case has been going on for too long. You're going to pay them what you promised them, or you're going to be held in contempt of court. It's wild to me. It's wild. I'm not saying he can't do that. I've just never heard a judge doing that over being able to pay his attorney. All right, let's finish this up. We got another Judge Stevens right after this.
Floyd's office with some potential dates because scheduling with Mr. Floyd's office has been somewhat difficult. It's been.
He takes care of his position. Y'all are going to have to make special arrangements to get here for this trial, because I'm not going to wait months. It's going to be just a few weeks, sir. Chris, do you understand?
Yes, Judge. Sorry.
You got your marching orders.
Yes,
Take
sir.
care of your obligations. We're going to see you back on April 15th, and I want to hear some good news, and then that case will be specially set. This is terrible. Anything else to add?
No, Judge.
Okay, I'll see everybody back on the 15th. Get a resetting, sir.
Thank you, Judge. May I be excused?
Yes, sir. Yes, sir. Thank you.
Thank you.
All right. Now we're like I just said, we're still in Judge Stevens' court. I think I have someone to thank real quick. Yep, Grizzly Old Fart. Thank you so much for the 5 gifted memberships. Welcome to all the new members. Thank you so much, Grizzly Old Fart. That's awesome. Thank you. Let's go. Hi, church lady.
Probation. Come on up.
This one is going to cause this is interesting. This is going to cause a lot of conversation. I've got a lot of questions. So, yeah. Let's just go.
We now call 235047, the state of Texas versus Andrea Shelton. That's you.
Yes, sir.
And Ms. Smith is the probation officer in this case. I've received a letter dated February 26th that states you are failing to adhere to the conditions of probation, which this court is not happy about. Have you gotten a copy of this? Have you seen a copy of this?
That's the first time I've heard of anything like this.
There's a problem.
What's the problem?
I'm about to tell you.
Ooh, the attitude's already starting. Grab your popcorn and your Coca-Cola. You're not going to be able to relax though.
On January 26th of this year, probation office obtained written verification that indicated your last doctor's appointment was on August 28th, 2023. The doctor.
Oh, that's actually, I think that's probation. This isn't this is a probation thing. She's already you'll hear what the case is. But I don't think she has an attorney anymore because the case is it's over with for all. I don't know. I don't know how to explain it because this is a weird one. But yeah, I think that's probation.
Document advised that you were scheduled to return on December 8th, 2023, but failed to do so to the doctor's office. Is that right?
Yes, sir.
Due to the time frame, this indicates the defendant would be out of her mental medications as of December 8th, 2023. Of course, all medications that are prescribed must be taken. Do you understand?
Yes.
What happened on that?
I haven't missed taking my medication. Every time I go report, I have my medication on me.
This says that you were to return on December 8th, I guess, to the VA.
I haven't missed any appointments.
Did you return on December 8th, 2023 as required? Did you or did you not?
Yes, I did.
This says she didn't.
She told me she didn't. She had to call them and reschedule. I don't know. I think work interfered or something.
Additionally,
I mean, that was so long ago, that I probably don't remember. That was in 2023. We are in 2024.
Are we?
Yeah. So that was so far ago. I haven't missed any appointments.
It was
I
just
did just miss one. I did just miss one appointment, but
it was
I'm
just a few
still
months
current on
ago.
my medication.
It was just a few months ago. It was in December. This also goes on to state that you failed to adhere to the GPS monitoring device. As of Johnny's Auto, on a document provided on January 26th, you were $575 behind on your GPS device payments. Your monitor has been deactivated on that date. Thus, you are not following the condition of the GPS monitoring. Would that be true?
No, it's not, because that wasn't one of my conditions that I signed for. I didn't sign for ankle monitors.
Let's see. What do we have on that issue?
Yeah, again, I don't think that's a defense attorney. I think that's her probation agent.
For some reason, I don't. Here, can you find the
I have
Lacey? I can't.
the
I don't have
information from
probation.
Johnny's.
Here, can you find the probation order?
Good.
Quickly.
Good. She was found not guilty by reason of insanity. You're just having probation monitor her.
Oh, okay. She's not on a probation status of any reason.
There's a special
okay.
prosecutor involved. So
Okay, who's the special prosecutor in there? Was somebody supposed to be here?
Anderson from Florida. No, sir. I don't think he was notified because it doesn't say on there that.
Okay.
But there was.
From probation, what is it that she is ordered to do that she has failed to do. Yes, ma'am.
That'd be hilarious if he did say that, Mr. Allen. I'm still gonna make a montage of all the times Judge
From
Simpson
what
says
I
Mr. Allen.
understand,
Mhm.
she came
But
with,
did you guys hear though? She was found not guilty for reasons of insanity. Now, they don't say what she was actually charged with. They don't say. At least I don't think they do. I don't remember hearing it. But she's just free. She has to, document her medical visits to the doctor and make sure she takes her meds and wear an ankle monitor. I really wish they said what she did. Because that just seems me like she seems normal. She just seems like she has an attitude problem, right? Maybe that's why people should take their meds. Yeah, I'm not going to comment on that because I don't know. Like I guess I just did, but she does. She seems perfectly normal to me. But again, that's why meds are important.
the GPS monitor to my office. There's no actual, let me see. We were under the impression that it came from the court.
Yeah, I want to know what authority I have over her right now. Does anybody know?
Just, whenever a person's found not guilty by reason of insanity on a violent crime, you have the ability to either have them monitored outpatient or inpatient, and I think you decided on this one outpatient. But I don't know, as far as if she's not following the regimen, then I think you can place her back, you can change your mind and have a hearing and put her back into.
Yeah, I want to know what my remedies are.
I think that's.
Which
the
is
remedy
what?
would be to put her back in a hospital, or put her in a hospital if she's not doing it outside. Because it was a violent crime that I think she was charged with.
Okay.
If you did order the GPS device in, looks like October of 2022, so.
All right. That has to get done.
Judge, as far as my appointments and stuff with my doctors, I've been going to my doctors. I actually just got on a new medication and I've been taking my medication. I have just missed one appointment this March, but I haven't been missing any appointments.
The GPS device is what I'm most concerned about, so
Well,
that we know.
Well, the thing is, I'm not on house arrest.
I'm sorry,
Judge.
did you interrupt? Don't interrupt. Let me finish my sentence.
You can-
The court is going to order certain reasonable conditions, and if not, then I will change the order and place you back in confinement in a facility. That's my remedy if you don't follow the rules or if you're defiant. These are easy to follow. They are, let's make sure we know where you are at all times and you report to the doctor regularly. Otherwise, you will lose your freedom. Is that clear?
I'd rather use lose my freedom than have to walk around with ankle monitor.
Then,
You're not tracking.
then send me an order and we will have a hearing. You're either going to follow the rules or not. It's that simple. Send me an order, we'll have a hearing. I will decide whether she needs hospitalization
Okay.
but defiance is not an option with this board.
Got reviewed by Dr. Groupon in the last year, so you're not worried
Defiance
about
is
my
not,
psychological state at all.
that is all,
Have
that
I
is
been
all.
reviewed?
We will be, you're defiant on the rules. You're not following the
She
rules.
told me I could take off my ankle monitor. She told me that she talked
Is
to
that
me before.
true?
Yes, she told me that she
Johnny's
talked
told
to.
me that they wanted their monitor back because
She's not paying. Okay.
And so
Well,
I
you have
told
to
her,
pay
we'll
for the
give it back
monitor to
to
have it
them.
monitored, man. And just your failure to pay, that's your fault. Everybody's got to pay for the monitor. So if you don't have the monitor
Why are we
on,
tracking
that's a
my
problem.
location?
You're going to interrupt me we're going to do this all day?
No, sir. May I speak?
Yes, quickly.
I check in every month with my probation officer. Nobody tells me when to go in and when not to go inside. I
I'm
don't have a
ordering you to
curfew.
have a
I don't have
GPS.
a curfew, sir.
I'm ordering you to have a GPS device. You will pay for it until further orders of the court, so we know where you are. It's that simple. Either do it or not. If it's not done within 2 weeks, let me know. You will be brought here and we will take further hearings up as to whether you should convert your freedom into a hospitalization because you're not following the rules of the court setting. These are simple. These are simple. That is all. Get a resetting. It's your choice. You're going to make a choice. On Julian Perez, 2 weeks.
2 weeks.
Julian Perez, come on.
I would rather lose my freedom than wear an ankle monitor. Says nobody that spends time in jail, right? Everyone that's in jail. I'll wear a tether. I'll wear a tether. Just let me out. Give me a personal recognizance with the tether. I don't know. People. All right. We're switching up. Go to Judge Simpson. And I am sorry to say Buff Lift was off today. So we have no Buff Lift. I'm just going to throw that out there. I don't want everyone to be disappointed all at the same time when the video starts. So I'm going to disappoint you before the video starts. You know, because that's how I roll. That made no sense either. Oh, you guys are awesome. All right, let's go.
What were we intending on doing today?
Well, Your Honor, there's two things. One is a pretrial, and I was also informed prior to today that there was a violation.
There is correct.
I'd like to address.
All right. One thing, though, I did notice today while watching Judge Simpson, you know, we'll get to Mr. Allen, but this officer, she just walks behind him. She knows when they call the case, she must have a list of the people that have violations. So she just immediately walks back there. Mr. Allen always waits for the Mr. Allen. So I was hoping to, when I make the montage, the Mr. Allen montage, that I would throw a different name in there. But yeah, she just assumes the position. Also, Detective Rachel, no idea. This is a new judge. This was his first day today. Very first day on the bench. I think he's like 18.
The violation first, if that's okay with the court.
That would be what I think needs to happen.
Your Honor, Ms. Reiser and I did have an opportunity to review the violation report. I did indicate to my client that on two occasions, one in February and one in March, there was a small amount of alcohol in his system. I'm going to assume for the sake of argument that all of those other tests were there was no positive result. Your Honor, I explained it to my client. My client indicated to me that he does use, on occasion, mouthwash. And on those two occasions, that's why there was a small amount of alcohol in his system. The court notes that I believe I don't have.
Well, that's what he told you.
Yes.
And that's why you're relating that to me?
That's exactly right, Your Honor.
Okay.
Your Honor.
Keep going, please.
I'm sorry?
Keep going.
Okay, I don't have the report in front of me, but I believe both of those were in the evening. It's part of his evening process.
You can look at it. Because those, did you? Because those are, what kind of mouthwash?
He's got that good mouthwash. You know, the kind that everyone wants and not everyone can have. That good. These guys, everyone who uses the mouthwash excuse needs to just watch LawTube just once. Just do it once. And you'll find out, okay, I got to use a different excuse. Mouthwash doesn't work.
Yeah. 0.021 and 0.023 is that what you're referring to, Your Honor?
Yeah, but then what is more disconcerting with the excuse that your client is giving you that you are relating to the court is that then there's a retest. So that mouthwash was hanging around for a while.
Well, Your Honor, let's see. 11:32, about a half an hour on this one, and it was going down. And about a half an hour, a little bit more than half an hour on this one, and it was also going down.
Those the same days?
No, one is on the 25th,
yes,
and one's on the 22nd, for February 25th and March 22nd.
Yeah. The one
You don't tell me, tell me.
I'm sorry.
Yeah, approach it.
I got it.
So the first one was after, I know February was after the football game.
It was what?
I'm watching an NFL football game.
Yeah.
I watched the game. I went in, brushed, and right away blew, and it didn't register. So then I waited till the required time and watched another TV show, and then blew a compliant test. And then the second one was after I waited 30 minutes after popcorn brushed, rinsed my mouth again, then waited 10 minutes, and then blew, and it's worked.
Your Honor,
So then I waited for retest, and the retest was okay.
Your Honor, after looking at the report again, I noticed that both tests were in the evening. I'm assuming, since there are no other tests referenced, all the morning tests were negative, and all the other evening tests were negative except for those two. That's all I can say at this time, Your Honor.
I've never heard of mouthwash lingering that long, first of all. And that mouthwash, particularly as it's being described, would hang around that long to blow numbers. And I'll be honest with you, I don't believe it.
Okay.
At all. But if that's your story, then that's a story you're going to give me, and then I got to do what I got to do. Is that really what happened?
Sparkle Poots. Judge Slavin and I have actually talked about this. I don't think it was on YouTube. I think this was just in private about how he said that he was commenting on Judge Shackelford will sentence people to court watching. So if you're watching Judge Shackelford's court, she will have people on her Zoom call and it'll just say court watcher because they were sentenced to, however many hours of court watching for, whatever they pled guilty to. And he's like, that's the best way for law students to learn is just go watch court, go watch YouTube, just watch court. You'll learn a lot. Like we joke about it all the time. We know a lot more about court than these defendants walking in that think, it's the judge's first time hearing the story. Yeah, just spend a little bit, watch court, figure out how this system works. It'll help you if you're ever in trouble. It will.
Yeah, I was up late watching football. Yes, with my girlfriend.
I don't doubt that. I'm just saying, you're saying that's the reason for the alcohol. Is that what you're telling me?
That's what I want to tell you.
Okay, I understand what you want to tell me.
No.
I also understand. I didn't just wake up yesterday and start doing this. So I want to make sure that that's what you want to tell me.
Well,
before I do what I have to do, if that's your story.
Yeah, man, you know what? He's probably a Lions fan. So if I just tell him I was at the game, he's like, all right, you know what? I'll give you a pass on this one. Wait, you know what? You know what? They lost that game. Nope, you're going to jail. That's not how it works, man. Not how it works.
So that is not.
That is not what?
That is not my story.
Okay. So now you have lied to the court. You lied to your attorney so that they could lie to the court. So you want to tell the truth or not?
I was with my girlfriend while we were watching.
What'd you do?
Had a glass of wine. Had a glass of wine with my girlfriend.
On both of these occasions.
She drinks wine.
Yeah. That's what I thought happened. You actually drank. So if you did that, why'd you lie?
Because all the other times I was good. I haven't touched. I haven't wanted.
Oh, I know that. So
honestly,
why did you lie?
Because I knew it was wrong.
I think he said it was a .021. So it's still a fairly low reading, but when you can't have alcohol, that's still higher than what you're allowed. But I could be wrong, but I think he said .021, which a half a glass of wine kind of makes sense in that range. I think. I don't know.
What?
I knew it was wrong to have the glasses of wine with her.
So why didn't you just admit that you had it? Because see, now what I have to do is I have to then release you theoretically. On an I have to release you theoretically. You're here on an OWI second. I put you on testing or monitoring system, below numbers. Then you come before the court and you lie to me. What?
I apologize to the court. Amen.
What were we intending on doing on the case?
Your Honor, I did have an opportunity to discuss the matter with Ms. Reiser. We were going to ask for about a 30-day adjournment. She indicated she was not going to make an offer until my client earned an offer.
Yeah. This probably didn't help.
Ms. Reiser knew about this, Your Honor, before she made that comment.
Yes, I'm sure she did.
Yeah, I wonder if he would have just walked in and said, I had a glass of wine with my girlfriend. We watched the football game. I had a glass of wine. I don't generally drink. It always comes up negative. This is the one positive I had. It might be different. But yeah, lying to the court. Also, making your attorney lie. That's never going to go well with Judge Simpson. If he would have just told his attorney the truth, the attorney would have fought for him. He would have said the exact same thing I just said. One, this is his first positive test. I think it was a 0.02, so it was low. Now, if it wasn't,
be wise to adjourn this out 30 days.
If it was a 0.2, then yeah, that was a lot more than one glass of wine. So, if anyone's late in the video and can tell me when you catch up, but I think it was a 0.02. All right, let's finish this one up, and then we're going to Reno.
So I'll adjourn this matter to April 17, 2021 at 9 a.m. or as your invite indicates. I will find that the defendant violated his bond conditions of no alcohol use. The defendant's bond will be set at $25,000. I'll give a 10% privilege at this time on it, but defendant, if he posts that bond, cannot be released from custody without a scram tether, and it must be in place. Defendant is remanded.
Thanks, Creighton. Is it Creighton or Creighton? I think it's Creighton. All right, Reno. Let's go. Yeah, don't lie to Judge Simpson. Don't have your attorney lie to Judge Simpson. And it's a public defender, so the public defender was that. Without rewinding, I'm trying to remember which defender that was. I feel like I know all of them at this point. But yeah, he's on. They're all in really good standing with Judge Simpson. But I'm sure that he just talked to him for like 2 minutes before that hearing. So he didn't drill him and like, we're really going with the mouthwash story. He's like, all right, that's your defense. Let's go. That's what I'm guessing. All right. Yeah, Reno. You guys are awesome. Let's go.
Morning, Mr. Alton.
Morning, Your Honor.
All right, and we will start with the jail special attention list, and that's the first person on that list is Tristan White. Mr. White, if you'd come forward.
Just to supplement the record, that my client's names are correctly spelled for no contest plea. We'll stipulate to a factual basis and we'll waive any formal reading of complaints or citations.
Thank you, Ms. McGinnis. I neglected to ask that question, so thank you for putting that on the record. Good morning, Mr. White.
Good morning.
Mr. White, you were charged in case number, let's see if I can find that case number.
Yeah, Deborah, my favorite one is Mr. Feaster's move with bond, because Judge Simpson does not like hearing bond arguments unless you file a motion ahead of time, so he knows it's coming. So he doesn't like the bond requests during his docket. So Mr. Feaster will always be like, my client is insisting that I that I talked to you about his bond. It's just funny. It's like, no, it's not gonna happen, but my client's insisting.
24 CR 03702, sir, with the charge of harassment, a first offense. Did you understand the charge?
Yes,
And is it your intention today to enter a plea of not guilty and set the matter for trial?
no content,
So,
no
Ms.
content.
You want to enter a plea of no contest? If that's the case, we're going to need a harassment waiver of rights. So Mr. McGinnis?
Thank you, Your Honor. I spoke with Mr. White and he advised me that he was going to enter a not guilty plea. He just changed his mind just now. And just for
Lisette, I hope she's okay. I hope she's okay. And yeah, no, I'm glad you're here, but I think that might be a little bit more important right now. But yeah, keep us updated.
to supplement the record as well, there was a competency evaluation. He was found competent. I don't know if the court's already reviewed that or not. So, Mr. White, if you want to enter a no contest plea, I'm going to have to do some paperwork and send it.
No content? That sounds like my channel. I had to. No context. Yep. This guy's on fire already.
Up to you. Do you want to go off record and just talk to me one-on-one, or how do you want to handle
No contest. No contest. I'm not looking to go to trial. First of all, if I have a waiver for a stranding order, do you guys know about that, or if that's been vetoed?
So, Mr. White, what Mr. McGinnis, your lawyer, is saying is that in order for me to take a plea of guilty or no contest to the very serious charge of harassment, you have to sign a pretty complicated waiver. So we're going to have to send that waiver up to you. You're going to have to go over that with Mr. McGinnis. So I'll trail your matter so you and Mr. McGinnis can go over that waiver. Do you understand that?
Okay, question.
Yes.
Is there a witness saying that I'm guilty of harassment?
Yes, there probably is, or the city attorney wouldn't have gone forward with the charges.
Okay.
So do you want, let me just.
All right, I can't let this go. I pity the fool that vetoes my no content. Yeah, sorry. I'm not good. I'm not good at I can't even think of the right word. You know, when you pretend you're someone else. I can't do that. But yeah, couldn't let that slide.
See if I'm looking for the
I don't think so.
complaint. Mr. Elton, could you read Mr. White the complaint so he gets a better idea? I don't have that in front of me now.
Yes, Your Honor. City of Reno versus Tristan White. I, Wade Yonker, hereby complain and say that Tristan White has committed the crime of harassment, to wit, that the defendant on or about March 21st, 2024 in the city of Reno, state of Nevada, in the vicinity of the 100 block of Fulton Alley, did unlawfully threaten to cause bodily injury or cause property damage and placed victim Yonker in reasonable fear that the threat would be carried out, all of which is in violation of NRS 200.571. And that's dated and signed March 21st, 2024. The allegations are that Mr. Yonker, who's a Reno city ambassador, was pressure washing the roadway. Mr. White did not appreciate.
I was on private property.
I'm just explaining what the police reported. And as Mr. Yonker was driving away, the allegation.
He was messing with somebody making a pressure wash video? Okay. Mr. T, you're staying in jail. This kind of came full circle from the conversation we had at the beginning of the video. Messing with someone making a pressure wash video. We all enjoy those, man. Stop vetoing.
Is that Mr. White had a knife and was approaching. This is all after he was making aggressive statements toward Mr. Yonker.
All right, thank you. So, Mr. White, you understand. My only goal here is that you understand the charges against you. Do you understand them?
Knife was found on my person, so where's the evidence?
That's a yes or no question.
Pardon me?
I don't want to hear the facts of the case from you because you have a right to preserve your defense. Do you want to
Okay.
enter a plea? You want to enter a plea of not guilty and we'll set the
going with
matter for
I'm going
trial?
with the no contents right now. I need to know the
All
details
right,
of
well, you
that.
can't go to the, listen to me, you can't plead no contest right now because I need for you to go over the constitutional rights and possible penalties. This
Okay.
is an enhanceable offense. If you get 2 more convictions, if you're convicted of this today and you get 2 more, the third one's a felony and you could go to prison. So I want you to be aware of that. So I'm going to trail your matter and allow you and Mr. McGinnis, your lawyer, to discuss the paperwork, okay?
Okay, so what is the detail between this restraining order paper that I got? What is that about?
That's probably that may be out of the family court or one of the civil, the Reno Justice Court. You may have gotten a restraining order as well.
Did he say destraining order? So he's vetoing the no content destraining order. Man, sometimes you don't have to make content. You don't. The no content, he's making it for me.
The restraining order is civil, and and this is a criminal case.
Okay,
so go ahead and have a seat. Have it. Yes, sir.
Question. Without, I just told her a question. She's looking for a question right now. Question. The plaintiff would still have to show up at trial, right?
Yes.
Okay.
All right, so we'll trail this, give Mr. McGinnis the opportunity to speak with Mr. White. So the next matter is.
He thinks he just had a mic drop moment. The plaintiff still has to show up, right? Yeah, all right. And he just walks away. Yeah, the plaintiff isn't the victim. Not necessarily, buddy. You're courtroom genius right there. And he comes back. He comes back. I got the end of his trial, or the end of his hearing. Don't worry. We have one more in between it, though.
Derek Lang. Mr. Lang, if you'd like to come forward. Good morning, Derek.
Good morning, Your Honor. Mr. Neal, how are you doing this morning?
I'm good, thank you. Just give me a moment to pull up your case.
So, real quick, I would just like to exercise my right to represent myself.
Mr. Lang, hold on a minute. Let me pull up your file.
All right. All jokes aside, when I hear I would like to exercise my right to represent myself, I immediately start paying attention.
Give me a second. My computer's a bit slow. All right, Mr. Lang, it looks like you have a number of matters. The 2 are a revocation hearing and 1 is a sentencing hearing. They are 23 CR 13218. Thank you for your patience. My computer is a bit slow this morning. All right, so this is a revocation hearing on a petty larceny charge. And it looks like this is, you have been before the court for violating your court order.
Oh, you guys are killing me. We have Mr. T and young Ron Jeremy. Oh, I can't do this. I was not expecting this. Oh, you guys, keep it up. I love it.
At least once before in March, on March the 4th, and you were not revoked. And I'm looking for a look at the disposition and tell you what you're facing on that petty larceny charge. Just give me a moment. That is that you were found guilty of petty larceny on October 23rd, 2023, and you had a sentence of 30 days in the Washoe County, 180 days in the Washoe County Jail, suspended for 1 year with 30 days up front consecutive to all other charges. The conditions were that the only condition was that you obey all laws. So you have 180 days minus 30. So you have 150 days that's hanging over your head in that matter. And so let me keep track of those for you. All right, and then we'll go to the next matter. You have another revocation hearing, sir, and that is 24 CR 03439.
It does look like it though. The guy behind him, I don't. It's just the exact same color as his hair. Like that is kind of weird though. When Peeps said he has a man bun, I'm like, he does? Oh, he does. And then he moved. I'm like, oh no, that's the dude behind him. Oh, cameras, fun. Let's go.
And that, sir, is a trespass charge. And the disposition in that matter was, looks like 60 days in the Washoe County Jail pursuant to your plea of no contest on March the 30th, not too long ago, March 20th, 2024. You entered a plea of no contest. You were found guilty and you were ordered to stay away from the Rayleighs on South McCarran, obey all laws, and participate with Reno Behavioral Health. That's a 60-day sentence, suspended for 1 year. So, and that is probably going to be concurrent because I don't see anything that says it was consecutive. So that would run on top of the 150 days. Just give me one more chance to look at the last file that we have for you, sir. And that is 24C.
Oh, Lolly, that guy. I didn't add his clip into this. It wasn't anything, special, unique, or anything. But he's actually very intelligent. He was very well spoken, and I was not expecting it with that hair. I was expecting him to be, borderline a hippie. I'm not gonna lie, I judged him, and then he came up, and he was the smartest person in this entire docket from the jail side, at least. Janie Marshall, thank you so much. I appreciate it. Thank you for being a member. Thank you. All right, let's go. We're winding down. Got about 10 minutes left. All right, let's go. Thank you again, Janie.
CR 03832. And that, sir, is, just a second, and I'll pull that up for you. This is a sentencing hearing pursuant to your plea on a trespassing charge. And we continued that for a pre-sentence investigation. Your rights were explained. And I took your plea and we continued this over. It looks like there was a trespass. You entered a plea. Oh, sorry. There was a trespass, a disturbing the peace, and petty larceny, which were dismissed with prejudice pursuant to your plea of no contest to assault, placing another in reasonable apprehension of immediate bodily harm. So those are the cases you're looking at now, sir. And you want to waive Mr. McGinnis saying anything on your behalf? Is that what you'd like to tell me, Mr. Lang?
Yeah.
All right, well, hold tight then. I'll hear from the city attorney and I'll allow you to represent yourself in the sentencing. Do you have any objection to that, Mr. McGinnis?
I think he's going to place himself and jeopardize himself, but certainly if that's what he wants to do, he can exercise that right.
Thank you. I appreciate that. I agree. Mr. Alton?
Your Honor, are you asking for revocation and sentencing recommendations?
Yes, I am. And
Okay.
I think that the matter was continued over from the first to allow the city to make contact with the victim of the assault to see if they wanted to be present. Do you have a victim present this morning, sir?
No, Your Honor, but we did reach out to Rylan Darisi. She's the manager there at the Starbucks on West 5th Street where this occurred. She did not respond to us. Based on all of the cases, Your Honor, this is pretty egregious. He threw an item that appeared pretty heavy at the victim, missed her. That was after he got in her face, raising his arms and fists at her. So there were maybe a couple of assaults there, but got in her face, threatened her, and then came back and threw an item at her that missed and broke. It looked like it was a metal container for some kind of syrup that broke when it missed her and hit the wall or whatever behind her. He's already pled no contest to the assault, so that's essentially a violation on the revocation cases. Based on all of that, he does have a terrible criminal history with just continuous trespassings. He has battery in there. He has alcohol-related offenses. Based on all that, on the assault, the city's recommending 90 days in jail up front, and that he be revoked on his other cases.
And are you looking for 90 days concurrent or consecutive to the other jail sentences, sir?
Based on the violent nature, Your Honor, I am asking that the assault be consecutive. I would not object to the revocation cases running concurrently to each other.
Thank you. All right, Mr. Alton. So, Mr. Lang, the city attorney is recommending that you revoked on the 150 and the 60. The 60 by law, if it wasn't indicated to be consecutive, will run concurrently. So you're looking at 150 days on the revocation hearings. I am going to go ahead and revoke you based upon your plea of no contest to and 60 days concurrent. What would you like to say on your own behalf relative to the new charges of assault?
I didn't quite catch all that. You cut out.
Your Honor, you did. You cut out for about 7 seconds, 10 seconds.
All right. Well, I apologize. We're trying our best to try to make this work. So, Mr. Lang, I'm going to go ahead and revoke you on the 2 underlying sentences because you have entered a plea of no contest to the new assault charge, which is a clear violation of your suspended sentences. So you're looking at 150 days. The 60 days I will run concurrent to the 150-day sentence. Now I'd like to hear your position relative to the sentencing on the assault matter. Why shouldn't I put you in jail for what the city has asked for 90 days consecutive?
It's just the problem is here at the jail they have me on the wrong medications. That's why I was trying to reach out to Reno Behavioral. It's not anything. It's just I was without my medications for 3 days when I was out on the streets, and I was kicked out for prejudice disposition. I was just sitting down there enjoying like water, and I don't agree with people being prejudiced. I did get out of line because of my medications were all. I didn't get my medications. I've been trying to go to Reno Behavioral. So the only thing I can ask for, if I am going to be here in jail, if I could be maybe ordered to be transferred to on a legal 2000 and get inpatient services at Reno Behavioral.
Thank you. You have not been found to be incompetent at this situation. I understand, and you were ordered in one of our last meetings to make contact and be treated at Reno Behavioral, and you didn't do it. So I'm not confident that you would follow the court's order relative to your mental health treatment. You already have to advise the court that you were off your medications, and a lot of that is voluntary on your part, Mr. Lang. I am going to go ahead and accept the city attorney's recommendation, and I'm going to sentence you to 90 days in the Washoe County Jail. That sentence will run consecutive to the 150-day sentence that you've just been revoked upon. And I'm going to wish you good luck. You are in charge of your mental health. You need to monitor that, make sure that you're on medication when you get released from jail. And you can appear at Reno Behavioral Health and submit yourself to treatment with them.
All right,
sir. I wish you good luck.
All right. Yeah, young Ron Jeremy. He didn't do terrible. He asked the right things. He wanted what he wanted. He said he wanted that, and the judge is like, "Yeah, I can't do that. Sorry." But he tried. His attorney could have tried for him too. The attorney probably said, "No, you're not going to be able to do that because of this, this, and this." And that's when the guy's like, "Okay, well, I'm just going to represent myself." That's what I think happened. Anyways, back to Mr. T. We're going to let this play out. There's like 5 minutes left of this. So, yeah, we're going to let it play out. And we I haven't rated KCC in a while. So, let's jump over there after this. So, I set it to raid KCC. So, let's jump over there and say hi to her after this. And then let's go hang out on Discord. So I'll be in Discord for a little bit tonight. I'm going to jump over and say hi to KCC for a little bit. Then we're going to jump over there. All right. Let's go. Let's finish up with Mr. T. Did I miss something? Nope. Okay. Thank you all for the super chats, the gifted memberships. Thank you, everyone, for being a member. You guys are all awesome. I will see you all tomorrow if I don't see you tonight. Until next time. Bye.
How about Richard Blackwood? Oh, no, sorry. It looks like we're at the end of the docket matters. So, how about Richard Long?
Your Honor,
Is it-
Tristan White's still in the courtroom.
Oh, okay, thank you. Mr. White, if you'd come forward then, sir. All right, Mr. White, we're back on the record on 20.
Oh no, Mr. T's name is Mr. White. Oh yeah, sometimes you don't even have to write jokes; they write themselves.
24 CR 03702. And
I can't hear. People are talking. I can't hear.
all right, what I said.
Thank you, Skizrock. I appreciate it. Thank you for the super chat. There you go. There's your pause. Thanks, buddy.
Mr. White, is that we're at 24 CR 03702. We're back on the record. You had indicated that it was your desire to enter a no contest plea to the charge of harassment. Is that correct?
Yes, but I want to revoke that statement
Okay, and you want to enter a plea of not guilty instead?
based on the basis of I was harassed on video.
Okay, stop. I will accept your not guilty plea. The reason I don't want to hear the facts, Mr. White, is that you're presumed to be innocent when you enter a plea of not guilty. And if you tell me any facts were on the record, and if you change your mind at trial that you don't want those facts to be known, I don't want them to be on the record. So I'm trying to protect you. Do you understand?
All right. Okay.
All right, so I will accept your not guilty plea. I'll assign a legal defender to represent you, and I will give you a trial date now, okay?
Could I get Kathy? Miss Kathy?
Well, I'll see. Miss Burning is an excellent criminal defense lawyer, and she is in our pool. So I will see if she's available to be assigned to you.
Can I get a speedy trial?
Yes, you'll get a speedy trial, sir.
Thank you.
I'll take a look to see if I have anything, Your Honor.
It sounds like that Mr. White and Miss Burning have crossed paths in the past. So if we can assign her to Mr. White's case, that would be great.
Your Honor, unfortunately, we don't have anything with Miss Burning in these bench trial
right.
docket types.
Well, and because Mr. White has demanded a speedy trial, let's give him a trial within the next 60 days with an available lawyer then.
Thank you, Your Honor. That would be May 7th at, sorry, my computer just slowed down all of a sudden. That would be May 7th at 8 a.m. and that is with Mr. Loomis.
All right, so Mr. White, your trial date, because you've asked for a speedy trial, will be May the 7th. That's within about 30 days. And your lawyer assigned, Miss Burning, is not available in the next 30 or 60 days. So we're going to give you a lawyer by the name of Keith Loomis. I will order that you make contact with Mr. Loomis prior to the trial date so the two of you can be prepared to proceed to trial. Do you understand?
Yes.
All right, sir. And now I'd like to hear from the parties relative to bail. Has bail been set for Mr. White as yet?
There is no bail set currently, Your Honor.
All right, I'll hear from the city first. Mr. Alton, what would you like to recommend as to bail?
All right, I see on his pretrial risk assessment in this case that some kind of initial bail was set at $1,000 cash. That would seem appropriate in this case. He's 12 with a high risk. He has pending cases, misdemeanor convictions, felony convictions, convictions of violence, failures to appear. This case involved the report of him approaching after made a.
You read us the complaint, so I remember the facts from the complaint as alleged.
Yeah, and then getting to his criminal history, he's had several arrests already just this year in 2024. January arrest for trespass, January arrest for in a separate case, January arrest for battery, drug paraphernalia, resisting. Going back to August 2023, a resisting arrest, and felony arrest for some kind of excrement or bodily fluid by a prisoner, battery on a protected person. He ended up pleading guilty to that. So had some kind of gross misdemeanor conviction with a crime of violence. That's not even going back a year, Your Honor. He has an assault with a deadly weapon arrest in August 2023 as well on a separate case. I could go on for quite a while here. So with his very recent history of violence, with his failures to appear, I think the $1,000 cash is more than appropriate to protect the community as well as bring him back to court.
All right, Mr. McGinnis. Thank you, Mr. Altum. Mr. McGinnis, would you wish to be heard?
Thank you. I did review the Nevada pretrial assessment. He does score a 12. I think based on that and based on the representation by Mr. Altum about his criminal history, the city has met their burden on these Valdez Jimenez for a monetary bill. Would ask the court to consider a bondable bill instead of a cash only bill. We'll submit it.
All right, Mr. White, are you working?
Oh, I do not wish to bail. I was on private property, and
No,
from this
Mr.
moment-
Mr.
from
Whit,
this
Mr.
moment
Mr.
forward-
White,
From this
Mr.
moment
White,
forward, I
Mr.
refuse
White,
to
Mr. White, I'm not
do I
going to
have a
listen
lawyer?
to the facts of the case. My question to you is a yes or no question.
I mean, it's a
Are you
bullshit case, so I'm done talking.
okay? All right, then your bail is set in the amount of $5,000 cash only.
Thank you. I'm not bailing out. Fuck a bill. Bitches.
All right.
Yeah, I forgot that he dropped the hard F. I gotta wait. I think I gotta wait like 20 seconds now before I finish the video. The YT does not like hard Fs in the first 30 seconds or the last 30 seconds of the video. So, yeah, what's going on? We are gonna go raid KCC. You guys are all awesome. Thank you for hanging out. Yeah, so let's go raid KCC and then jump over to Discord for a little bit. I don't know what else to say. I'm waiting. I got 10 more seconds and then I want to play the outro. All right. Now we're down to 5 seconds. This commentary is awesome, right? Weather. Yeah, weather. Weather happens. It got cold here. I don't know why, but it got cold. It was hot, then it stormed, and then it got cold. All right. 30 seconds have passed. Okay, you guys are all awesome. I will see you all tomorrow if I don't see you at KCC's or on Discord later. Until next time. Bye.